Wait a minute, wait for a while. Yes.
May it be, Your Lordship. With the
Yes.
consent of the other side, I beg to mention item number 19 and 20, Lordship.
Mhm.
That will be taken after 2 weeks, Lordship.
Why? What happened?
Lordship, it is senior, I am Lordship led by senior standing counsel P.K. Goswami, Lordship.
And counsel Mr. So-and-so praised for and is granted 4 weeks time to prepare and argue the matter. Let's stop 4 weeks.
19 and
May I
20, Lordship.
19.
Obliged.
May I please your lordship? Lordship, I beg to mention item number 18.
Hmm.
Lordship, my senior Mrs. A. Gayan is out of station. We have the
Stated
consent of the other
that and
party.
counsel MSA guy is not available today. Is Union of India party already?
Yes,
already.
lordship.
Thus, prayer is made to adjourn the matter on our behalf. The petitioner's counsel does not have any objection. Appellant's counsel, let's stop 2 weeks.
Thank you.
Is clearly the consent of the appellant's counsel has been taken.
May I please, your lordship, with the consent of the other side, I beg to mention item number 63, Your Honor.
Hmm.
The council Lee sir have some personal difficulty, so.
It is
adjournment
stated that
because of
arguing
this-
counsel, Mr. Saraf, has some personal difficulty today. Prayer is made to adjourn the matter. Let's stop 3 weeks.
Obliged.
Yes.
Next is but I am paying for listing of my lord admission matter, my lord, the next week, my lord.
What is the matter about?
My lord, matter, my lord, regarding my lord, preventive detention of the my lord petitioner. my lord.
Get it listed next week. Whenever. Next week, not
Next
in
week,
this week.
next week, my lord.
It is already filed or what?
Already filed, my lord, 3 weeks time, the lordship granted them, my lord, to file counter, but yet not
All right.
file one.
Give me- Yes.
Obliged.
Pending matters में permission से कैसे? Why in pending matters they are making a mention? The office should fix a date. Why the matters are not being listed? Ask the registrar to tell me. Yes. List is matter. All right. Not an issue. Okay.
May it is your lordship. Your lordship, I pray for listing of 2 writ appeals. These are arising from the same common interim judgment. Your
Which,
lordship.
what is the date of the channel?
Your lordship, we have already filed this in April and it had come up on 22/5/2020
Mm.
last. However, due to difficulty of the senior advocate, we had prayed for an adjournment and lordship was fixed to list it after 2 weeks.
Mm.
Lordship, there's certain urgency.
For that gentleman, if the date has been granted by the court
Yeah.
or the adjournment is for 2 weeks and you want to prepone, you have to move a preponement application. You can't get it on mention memo. File a proper application.
It,
No,
we had only prayed
this is
for.
not the correct procedure. Absolutely.
Obliged.
Move a preponement application.
May I appeal, Lordship? I am appealing for listing my lord, fresh writ appeal, my lord. On my lord, Wednesday, my lord.
What is the date of the order, sir?
My lord, that is the 2/5/2023.
When do you want it to be listed?
My lord,
When do you want it to be
next
listed?
Wednesday, my lord.
Next Monday,
Wednesday, my lord. Wednesday.
Wednesday. All right.
31st.
Yes.
My lord, okay.
Daily list for orders, item 1.
My lord, this PIL pertains to removal of unauthorized structures.
Hmm.
Religious structures,
Yes,
to be
yes.
precise.
Hmm.
My lord, I appeal for the state of Arunachal Pradesh. My lord, may recall the last order dated 29th of March.
You were saying that there is some
Yes, my lord.
difficulties.
Now, my lord, in fact, the good news is, my lord, that the most difficult district is Arunachal Pradesh, namely district Papumpare,
Hmm.
wherein the Itanagar capital complex falls, including Nahar Lagoon. That is the district, my lord, where there are maximum religious structures.
Hmm.
So that district, my lord, we have cleared. I have got the report.
Okay.
So, my lord, in fact, substantial progress has also been made in 4 or 5 other districts also.
Okay.
So I'm expecting those reports. But the report of Itanagar capital complex, Nahar Lagoon, and district Papumpare is very much with me. But by way of an affidavit, I may.
Place them on record. Mr.
So-
P.K. Tiwari, senior advocate, assisted by Mr. So-and-so, submits that significant progress has been made for removal of the encroaching regular unauthorized religious structures in the Papumpare district, Nahar Lagoon and Itanagar,
Which includes Itanagar capital.
which includes
complex.
Itanagar and Nahar Lagoon. He further submits that similar steps have been taken in 5 other districts.
And 5 other districts.
5 other districts He prays for and is granted 2 weeks time to bring all these facts on record through by way of an affidavit.
Could it be 3 weeks? my lord?
3 weeks. Let's start 3 weeks. What about the other states? No illegal structure at all. Everything has been legalized by the church. And what about small state things become prominent? What about Nagaland? You already filed an affidavit. Ms. Das, you have seen affidavits of
Yes,
Nagaland?
Nagaland and Mizoram clear, my lord. In fact, Assam also, my lord, they have, if we go by the affidavit, they are clear. Only 2 religious structures are there wherein, my lord.
Only one.
One, yes. One in
Lordship,
Dibru-
regarding the district of Dibrugarh, only one religious structure is yet to be dismantled or regularized because the suit is pending before the municipal judge.
All right.
That's why.
Let's start 3 weeks. As per it.
Alleged.
I'll leave, please.
Item number 2.
This is a really ridiculous litigation.
Lordship, I have filed an affidavit on service.
What is this litigation about? Let us know after the division bench judgment, which has attained finality, what relief can your client
No,
get?
that was dismissed for default, Lordship.
Maybe understood. Tell us on merits. What case do you have?
Lordship, today I'm not so prepared. I was just prepared for this case.
So why should we restore? Let us
Lordship,
know.
let it come.
Twice you have already got it dismissed.
Lordship.
Why should we restore it again?
Lordship, it was just my mistake, Lordship, that in the cause list, my name was not shown. That is the reason, Lordship.
What do you say, sir? Should we restore and then hear it on merits? There is
Yes.
nothing on merits. We have seen the matter.
95 select list, they want appointment.
Lordship, but
And
they have said,
Our select list.
Madam,
is
division
different.
bench has already concluded that issue. That order has not been challenged.
That-
There is no question of going into that list now. You were placed at 47,
Lordship,
assuming the 20 were illegal appointments.
Lordship,
Some of them were regularized, some of them were sent home. How do you get a right?
Lordship,
Just read yesterday's judgment. A select list does not survive forever.
Lordship,
So
but there was a.
waiting list can't be operated contrary to the wishes of the employer.
Lordship, according to division bench, Lordship, that they did not follow strictly the division bench order, Lordship. What they did, some of them, they called over the telephone, some message, Lordship, and it was not properly done, Lordship.
Nothing that aspect has been taken care of by Leonard Singh. Anyhow,
Just
all-
one
all
shot, give it.
all right.
I'll be prepared, Lordship, one day.
all
Lordship.
respondents are served.
Yes.
All the respondents are served. This is an interlocutory application filed by the petitioner seeking restoration of the writ appeal number so and so, which was dismissed by this court for want of prosecution on 15/7/2019. Then counsel MS. Is your good name, madam?
SP Hussain.
SP Hussain submits that on the date when the matter came up before this court, that is 15/7/2019, her name was not reflected. Where is it mentioned in your application? No,
Yes, Lordship, my only S Ahmed was shown. I have mentioned in my restoration petition, Lordship.
read please.
Lordship. At page 9, Lordship,
Cause list वाला नहीं है, sir. There is no such thing in your application. You say that you were at Delhi. That is not our problem.
my junior counsel did not attend, Lordship.
No, then you are making a misstatement in this court that your name was not reflected.
In the prior one, it was not reflected. Second.
Now
one was-
this is
yes,
the second
Lordship,
round.
The second
So
ground.
how long the court should tolerate the absence of the counsel? No ground at all. All right, then on cost of 25,000.
No,
we
Lordship,
restore it.
This is a pro bono case itself, Lordship.
But madam, why should we keep on giving you such indulgence? And furthermore, there is nothing in merit. Why should we indulge in that exercise?
Lordship, just one hearing, Lordship. If Lordship
What
is
for?
pleased- Yes,
What
Lordship.
for? Let us-
Lordship, there was a particular order passed by the division bench which was not followed up in total, Lordship.
Then you file a contempt. You can't come in appeal. File a
No,
contempt for
I
that.
again filed a writ petition.
We
then as
understand. Writ petition takes care of the fact, the single bench order takes care of the fact the division bench has finally decided the controversy,
well. But there
which
was,
order has not been challenged any further.
No, Lordship, after that single bench judgment, Lordship, again I challenge
So
the
you
division
came
bench.
to the single bench seeking compliance or a clarification of division bench judgment or what?
No, Lordship,
Then-
I said the division bench judgment was not
Then file a
complied with,
contempt then,
not complied with, Lordship.
file a contempt. How writ is a remedy for that?
No, then I came for it appeal, Lordship, here. This writ appeal was not dismissed, Lordship, it was dismissed for default, Lordship. This
Madam,
was
we are
not heard.
asking you why your writ petition was at all maintainable. Your claim is that the division bench judgment earlier one was not followed properly,
Lordship.
not complied.
Lordship,
What is the remedy for that?
contempt.
Then you got your own answer.
Lordship, just give me one time, one chance, Lordship, one day, I'll just satisfy your Lordship, Lordship.
But division bench has held, my lord, the order of the division bench has been complied.
That's right.
That is why I just want to satisfy your Lordship, just one day, Lordship.
We are not sitting in review, madam. That order is already final. We will impose some kind of cost, 5,000 rupees cost for restoration. This is too much. You are taking the court for a ride.
Lordship,
So how many times the litigation will be entered?
Lordship, this is the first case in my career. I don't know why it has happened. It has happened. It's not my mistake, Lordship. First time in my life.
Pleads that it was because of some miscommunication that she could not appear to address the court when the appeal was called out for hearing. She thus urges that the litigant should not suffer for the fault of the counsel and praise that the associated writ appeal, which was dismissed for want of prosecution, may be restored and heard on merits. Considering the plea of learned counsel, MS Hussain, that it is owing to her mistake that the matter could not be pursued in the court, we are inclined to accept this application for restoration. The writ appeal number so and so shall be restored and listed for hearing on Thursday ka date dijiye top of the list. Thursday.
Highly, highly obliged, Lordship.
Item number 4.
Made please, Lordship.
Hmm.
Lordship, this PIL is filed against the impugn order passed on 18/5/2021, whereby a particular plot of land belonging to municipality has been allotted to a third party without following any due process or without calling for any NIT. So we have
What is,
been,
let's read the allotment. What is the nature of the allotment?
page 25.
Yes.
Since the petition dated 18/1/2021, along with the order of the Honorable Guwahati High Court in case number so-and-so dated 21/11/13 of Jyotirmoy Roy Singha and 15 others.
So that was in the purported compliance of this court's order.
And
Where is that order?
there is no such orders, my lord.
Let's see.
That RSA was dismissed, page 38. It was dismissed for default. None appears for the appellant. It is also submitted by Shri Singh that the respondent number 1, Shri Roopchand Singh, died long back, and he further submits that the appeal has abated accordingly on both the grounds of default as well as on the ground of event.
This is not the order.
This is the order. This is the order
They
dated.
are referring to an order dated 21/11/2013. This order is of 22/9/1997.
But the RSA they are referring to.
All right.
This is
Okay,
the only
okay.
RSA.
Second page dated. This dismissal is on. There is a confusion. We
This
are reading
below it
this
is
late.
written 21/11/13.
This is probably issuance of the certified copy. Mhm. Yes, who is appearing for the municipal board, Silchar?
My lord, I am.
Which is the order dated 21st November?
My lord, there is a confusion. My
No
lord, you
confusion, sir. This is intentional. Let us know the order. Which is the order?
My lord,
If your
order-
authorities can't even read the date of the order, they
Yes.
are incompetent.
My lord, order is judgment dated 22/9/19.
All right, what is the judgment? What is the judgment?
This is the order, my lord.
Does the
This is
judgment say that
Second
anyone
appeal.
has to be allotted lease?
Second appeal has been dismissed.
So where is the judgment? What is the import of the judgment?
They did not give any
So then,
sort of license.
There was no direction that the lease did be issued.
Not at all. my lord.
Then
Now they have renewed the lease which was given earlier.
on basis of some order of the High Court which doesn't exist.
That is wrong, my lord. I'll say that is the wrong
Read-
location.
Read where, what is the direction of this court?
The direction of the court is not there.
Then
My lord,
you
they have-
read your order, please.
This
What
order
are
is
they
wrong.
trying to do?
Yes, my lord, your lordship kindly see at page 25.
Yes.
Seen the petition dated so and so, along with the order of the Honorable High Court dated so and so. My lord, this Honorable Court never directed to issue anything.
Read the last 4 lines of this para.
Yes. My lord, the last 4 lines, and therefore, in compliance of above mentioned order of the Honorable High Court, and as per terms and conditions.
So
of the
what order
article-
was being complied with, sir?
My lord, this is,
So then we quash the order, ask them to pass a fresh order.
yes, yes,
All
it's
right.
very correct.
Simple as that.
Yes.
All right.
This Honorable Court hasn't passed any order to go for a lease. My lord, there is no such order.
Then this is a, then why should we give them liberty to pass a fresh order even? We'll simply quash it,
My lord,
saying that this is a fraud on the face of it.
my lord, what
They are
I
referring to a
understand-
non-existent order of this
my
court.
lord, possibly there was a lease earlier. They have renewed that lease,
Sir,
but
even the order is doubtful regarding whether it is a transfer or a renewal. Read please. Transfer, comma, renewal. What is it?
that I have seen.
Then there is no question, sir. It's favoritism on the face of the record.
But this is totally up to your lordship, my lord, because I'm also not satisfied with this order.
All right, all right. Who is for the private respondents? All right, argue, sir. Why shouldn't we direct this inquiry by the ACB?
Regarding inquiry, I have no question, but the form in which it has been filed, this has been under the shield of public.
Yes,
administration.
definitely. It's a public land. It is a
Not a
open land of municipal board, which was being used by the public at large. Why lease was granted?
It was not being used by public at. large.
Irrespective, sir, what is the procedure for granting a lease of a public land? Tell us.
The private respondents hearing, since the time of independence, they have been in occupation of the land under the municipality as less. Respondent number 1 as less.
Does that give you a right of allotment or a lease?
That lease has been renewed only.
Tell us from the order, it is a transfer or a renewal? Renewal of which lease deed? What is the date of the lease deed? Original, which was being renewed.
We have mentioned in our affidavit in opposition.
Let us see the lease deed, sir, original one. Where is it? Let's find out about the existence of such a lease deed. And a backdated renewal. Renewal being done in 2021
Yes.
of a lease which expired admittedly as per this order in 2003.
Yes.
Yes. What kind of procedure is it?
No, regarding the procedure, my lord, my basic objection is regarding the PIL.
Forget about that. We overrule your objection. Come on, merits.
There are documents, my lord.
Sir, show us the lease which was existing as per you from 1930 to 2003.
Lordship, we have annexed documents to our affidavit in opposition 26 number, page number 26 to 40. Along with our affidavit in opposition, which is the Jamabandi of the land records. Then
Sir, do
there-
you understand the term of lease?
Yes, yes. my
Very
lord.
is clear.
Yes.
Where is the lease? Simple answer.
No, there was no lease deed.
Then this order is fraud on the face of the record. If there was a no lease deed, what is it renewal for?
But a lease has been, we have been
A
paying. the
presumed
revenue.
lease. Is that so?
Yeah, on presumption of lease.
Oh, wonderful.
But what we have been in occupation of.
Please
as
tell
well.
us. Please tell us that there can be a presumption of existence of a lease in law.
Lordship, if, then that is really a matter of civil code.
Oh, is that so?
Yes, yes, my lord.
Wonderful.
And under the Transfer of Property Act and as if.
Sir,
the petition
in
is
non-existent document, Mr. Counsel, is being renewed and it is a matter of civil regarding a chunk of public land. to favor a private person and it's a matter of civil court. All right, we'll take care of that.
Yes, specifically the rescission of contract, if we take it as a contract. is
Why
the
should we
matter-
take it, sir? You enforce your right through a contract. We say that there is no lease. You yourself admit.
Yes, but we have been on presumption of lease, we have been in possession and we have been paying.
So you are trying to
Lease rent.
enforce your possession through an application. The document, does it say that because of adverse possession, you are being given the title?
No.
Is it
not
a transfer of
adverse possession.
title? No.
There are earlier round of litigation which demonstrate our possession over the land.
Mr. Counsel, what does the order read?
No, that order has been passed by the municipal board. There must be some lacking in that order.
Where is your application? 18-121.
Yes.
Read. What is the size of the plot?
5
Mr.
cut
Datta,
5 cut off,
what is the size of the plot?
5 cut off.
5 lakhs.
All right, we'll cause this order. He is not even having his application and direct the municipality to construct a park thereupon. Let it be used as a park. Absolutely. Change the nature of the land in the revenue records and use it as a park. Simple. So whenever they want to do a Durga Puja, they may do it, but no putting up of any boundaries, any structures. The allegation is, your reply says they were trying to put up a market on that. Nothing knowing. Let it be used as a park.
Lordship. The document that has been annexed.
Will you please show us your application? You are not able to show your lease. You are not able to show your application.
Yes, the page number 34 to 35, they have submitted. Is in the name of Chaudhary Singh, who is the predecessor of the present private respondent, my lord. By which
Council, either we are not clear or you are not able to understand. We want to know where your application is on the basis whereof this order was passed. Sita, have you filed that application with your reply?
Reply.
No, the application. On the premise whereof this order was passed.
No.
15/1/2021.
Not even the application is not even in existence. We can presume that. Your order reads that as a consequence of the application dated 18/1/21 and in compliance of this court's order, which is non-existent, the lease is being renewed. Remember. What was the authority, sir? The authority was executed.
So far municipal board is concerned, my lord, it will be converted into a corporation. So therefore, we need for our own purpose, for establishing office and all that.
What action is proposed against this officer?
They will pardon.
What is the action proposed against the officer? Is there a resolution of the board before this order was passed?
All these things are not aware.
This must be in your reply, sir.
But then these order,
Uh.
Lord, this honorable high court never say.
No, what we are asking you, this officer has exceeded his limits. That is for sure. So is there any resolution in furtherance whereof this order has been issued?
There was an inquiry. That inquiry will also.
What is your conclusion? Let us see the inquiry report.
Inquiry will also
Because
find.
this order doesn't reflect that there is any resolution of the board in furtherance whereof he is issuing this order.
Yes, sir.
This is obviously a fraud on the face of it.
My lordship. The
Just hold on, sir.
Silchar municipal board is.
Now, where is that inquiry referenced?
That at page 39, my lord.
39. He must be a Assam Civil Services officer.
That time, my lord, it was a chairman possibly.
No, executive officer, sir,
Oh, executive, yes,
not the chairman.
executive. Sir.
39 typed copy, relevant portion.
This originally is available at page 40.
40 is the original one.
Oh, this is just a site visit.
Site visit.
No. You are saying whether there has been any inquiry into the conduct of this man. Should be. Apparently, an executive officer takes it on its head and issues a lease deed. What business does he have?
Then of course, too much.
No authority at all.
Yes.
So we'll simultaneously direct inquiry against him. Whosoever the officer was. Yes, now what do you say, sir?
Yes, my lordship. We have submitted all the receipts of the.
We are asking you, where is your lease deed? Where is your application? Now, last question, that's all. Last opportunity. Tell us if you have it.
Yes, my lord, then we have to take those from a visitor municipal board. Because they
Writ
are
petition
not-
allowed or quashed, inquiry directed against the officer,
Much obliged.
and FIR shall be registered against him if required.
Item number 5.
Yes. Yes, gentlemen, you were to take instructions how this court has jurisdiction.
Yes, my lord.
Have you read the factual report, please?
Yes, my lord.
So now the factual report says that the detainee, alleged detainee,
Yes.
talked to the petitioner from Chennai,
Yes.
saying that he needs this, he needs that.
Yes.
Okay, then he was not found.
Yeah.
What is the status, Mr. Nath, of the FIR investigation?
Malad, the status, as per the status report, Malad, they have taken all possible steps, despite the fact that the cause of action doesn't arise here.
Hmm.
If Lordship kindly sees the FIR, because the FIR was lodged in the month of March, when he said that in the month of January, he left to Chennai.
He left for Chennai.
But the investigation case diary is available with us, Lord.
Hmm.
But one witness here, Lordship, I have seen. In fact, 164 statement of that particular person has also been recorded.
Hmm.
Well, he said that at that point of time in the month of January, this person with him, like, he met the wife of the husband of the petitioner at Chennai on earlier occasion. And when he was at his this particular village, this person, they along with the other accused person, they went to Chennai, and from Chennai, he went missing.
Hmm.
Well, I'd like to humbly place the case diary.
You read out from the case diary.
Well,
The recording will be in vernacular.
in
All right.
my lord,
Lordships can read it,
Lordship-
yes.
Lordship can read.
But your factual report itself mentions
Correct, my lord.
victim Abdul Rauf talked to one Shahidul Usman.
Yes, my lord. And in fact, Lordship will also find a witnesses there.
Hmm.
161 statement is there. After about 6 months, somebody called a villager and informed that the Abdul Rauf got married and he got settled. He will not come to Assam. That information was given to the wife, and she got the phone number. She has given the phone number to his brother, but ultimately that was not informed to
Informed to the police.
Not informed to the police. After 1.5 years, police came to know about that. But by that time, the CDR and all these things is not possible.
It's not possible. Not preserved beyond 1 year.
161 of Saidur Rahman, it is there, my lord.
Mm. But Ms. Nath, you will have to conclude the FIR. Keep on the efforts to search. Whenever anything
Correct.
surfaces,
Well,
take
I-
appropriate search.
I have discussed the thing with my IO, my lord. My lord,
If you file a closure report saying no jurisdiction, then we'll close this habeas corpus also.
Lordship, that or my lord, whether the other option, if they pay the learned CJM, my lord, for transfer of the case to the jurisdictional, because from that.
Whatever, if they do that,
Lordship,
all right. There is no jurisdiction here. And
But-
council must
But in respect of jurisdiction, my lord, section 178,
read.
yes, my lord, I am
Jurisdiction.
reading of the CRPC, my lord. 178,
Yes,
place of inquiry or trial.
yes.
When it is uncertain in which of several local.
So there is no uncertainty, sir. There is no uncertainty. Your client has talked to people from Chennai and he was LNRT.
Yes,
Your detainee. So then how it is a case of abduction from this, abduction from Assam?
yes, my lord. This is revealed from the inquiry report submitted by the IO, my lord.
Read please.
Dated 2nd of May 2023.
Yes,
The statement of the initially revealed that, my lord.
yes.
My
Read.
lord, kindly come to page 4 of the
Hmm.
inquiry report, my lord. In bottom. 6, line number 6 from bottom, my lord.
Hmm.
During the journey of accused Shahar Ali and Abdurrahman from Bongopi village, Kolgasi appears to deliver the consignment of ganja in Chennai to so and so. Shahar Ali called in those twice about not being able to find Abdurrahman.
that this
Hmm.
was he.
Yes, my lord.
He referring
Because
to.
the
he
Previous-
referring to previous.
Yes.
Previous incident.
Previous incident. That 164 statement I have given, my lord.
From the investigation conducted so far, it is found that Abdul Rauf has gone missing in Chennai. And there is nothing to suggest that any harm has been caused to him by Sir Ali. All right, Land Council Mr. Nath submits that from the investigation carried out so far, the IO has reached to a conclusion that no part of the cause of action pertaining to the disappearance of the alleged detainee, Mr. So-and-so, has arisen in the state of Assam so as to warrant the continuance of investigation at the police station so-and-so. He prays for some time to place on record the latest factual report in this regard, list after 4 weeks.
God bless.
Lordship, I'll take back the case there, my lord. Yes, sir. Lordship. Hold on, my lord. ठीक है.
Presence of IO mark condition.
Any look? Next day हमें court of prescribing is already court of court order.
Item 6,
Here, Your Lordship, on last occasion, they took time to file an additional affidavit, Your Lordship. That has not been filed.
Not been filed. Who
Order
was to
dated
furnish?
5
Madam, you have to file
Yes, Lordship, we have received instruction. I am praying for a 7 days time, Lordship.
MS Bhattacharya, place for and is granted. Further opportunity of a week to
In the
Fine.
IA, Lordship.
hmm,
In the IA, Lordship.
in the week to
Yes.
file the additional affidavit in interlocutory application number so and so, list after 1 week. Deeply obliged.
Lord.
Please, your lordship. My lord, the I has been filed for delay of a for condemnation of a delay of 49 days, my lord. So on the earlier occasion, my lord, one of the learned counsel appeared on
And
behalf
then
of the-
notice will go,
my lord,
issue notice to the respondents. Mr. Nayak, Mazumdar appears for respondents number 2, 3, 2 to 6. 2 to 6, thus comma, steps for service upon the remaining respondents be taken within 7 days, whereafter process be issued to them.
my lord,
This will,
my lord, respondent number 8 had expired, my lord.
so you take steps, then council further state that respondent number 8 has expired. So what do you want? His name to be struck off or what?
Struck off, my lord. We have made him a party as he was a party in the petition, my lord.
And his name thus may be struck off from the array of parties.
Lordship, I have the instruction to take notice on behalf of respondent number 7, Lordship.
7, Mr. Swanson appears.
Mr. DN Leader.
Madam, the respondent number 4 will be represented by the deputy commissioner.
Or MSM Bhattacharjee. Thus, comma, upon requests being furnished, comma, let notice be issued to the respondent number 1 only.
Obligation.
Rule is made returnable in 4 weeks.
One. Four bati.
Item number 10 and 11.
Lordship, here a review petition has been filed by us, my lord. In the contempt matter, there is a reflection in the order.
Hmm.
My lord, I have checked up, there is some defect in the review petition that has been rectified, my lord. Kindly take it up day after tomorrow along with the review petition.
Yeah, tomorrow. All right. List on 31st May as previous. Not.
Lordship.
Otherwise, this writ petition is not required to be heard by division bench.
Number 6, the matter contempt is.
Simply a order of posting. It's not a statutory notification.
Correct.
Well, we'll see.
Lordship.
Item number 12.
Yes.
Lordship, in this matter, there is a connected matter, Lordship. There is a similar read appeal pending. before
Argue
this
this
Lordship.
one, the connected writ appeal will be governed by judgment of this writ appeal. Argue this one.
Lordship, since that read appeal is already.
Transportation
admitted, I'm praying for
contracts granted in way back about 5-7 years back.
Lordship.
What is to be done now?
I'm praying for admitting this read appeal and take along with the. another-
Admitting,
Yes, yes, Lord.
what for? Make out a case for admission. Make out a case for admission, we'll admit it. What is the illegality in the order? A writ appeal can't be admitted for the askance, Mr. Counsel.
Lordship,
It's not a statutory appeal.
Lordship.
Yes,
Lordship, in that matter, Lordship, may kindly pass over for time being and then
pass over for the timing or,
time being.
all right.
Like,
Item number 13.
Ah, I know. They have granted it through tender. Oh. Yes.
might be your Lordship. It's read petition filed by the petitioners. Was dismissed by this honorable court because on the ground that it was delayed, inordinately delayed. But that has not happened in this case. Lordship, very petitioners have proved that this matter of records, that they are the owners of the land, is being under occupation of the respondents. The question of that, my grandfather allowed them to possess the land, and today I'm the owner of the land. I'm claiming the compensation, or at least there should be evicted from that land, Lordship. It's the question of delay doesn't come, Lordship. It's continuing occupation,
1965 to 2023.
Lordship.
So why is it not a delay?
Beg your Lordship pardon.
The learned single bench observes that the delay is a cause of action, if at all, accrued in 1965.
Lordship.
So why the delay issue is not germane to this matter?
No, but at that time, my grandfather allowed the department to enter the land, and they requested to start a project. He allowed.
He allowed.
Now
Then-
he died long back. Now land is in my position. I'm the owner of the land.
All right, file a revenue suit, get a declaration. Why a writ petition?
No, because lordship, that it was not that land was requisition acquisition. It was on by request of that government, that particular department. We have
So
allowed
what
it.
is your claim? What is your claim in
My
it?
claim is that they should be now, either they should pay, but I am the owner of the land now. Petitioner is the owner of the land.
So what is the relief you have sought? Let us see.
They should be, they're still occupying the land. They're still occupying the land by establishing their one office and some go downs.
So when was the office established?
Lordship,
When was the office established? What is the date? What is the year in which the office was established?
that was in 1965, lordship. At least lordship, the notice may be good. Now, this.
What is the relevance of the judgment you cited at para 54?
That is lordship, it's not very
What is it
relevant.
to do with this present litigation?
That is not very relevant, lordship.
Then all right.
That is not relevant.
All right, issue notice to the respondents. Steps for service be taken in 3 days, and thereafter process be issued. Just
Oblige.
John decided against Rashtra, the government had criminal built. It is dispute on a fact. And be the Supreme Court of the he was the same person. Would be in. Yes,
Item 14.
Well, matter me possible for time being, madam. My senior likes in analogy. madam.
Vasu.
Similar matter has already been admitted, my lord, connected arising out of the same judgment and order.
Let Mr. K. N. Chaudhary's attendance be marked, then he will be able to put in the bill of fees, not otherwise.
Much.
Item 15.
Meet with your lordships.
Yes, Mr. Chaudhary.
My lord, the issue here is, my lord, regarding the seniority and promotion. There was a vacancy of, my lord, FDA in 2001. That was a vacancy for STP against which the appellant was selected and promoted. And the subsequent vacancy arose in 2006. And accordingly, one of the seniority has been fixed in terms of the year of vacancy. Now, my lord, the honorable single judge has held
Yes.
that on the basis of the roster, the seniority cannot be determined. Now, my lord, while considering this and coming to this finding, the
Yes.
relevant rules were not taken into consideration, my lord.
Then you
rules-
file a review? Then you are required to file a review? Is
My
it
lord,
not
I'm
so?
before your lordship. Because
You are saying that something was not considered.
my lord,
So then,
now
was it pleaded? Was it pleaded in your affidavit?
I was not in the, my lord, petition.
You means not Mr. M. K. Chaudhary.
I understand, my lord.
The client was represented.
Now,
So
my
whether
lord,
there was any such pleading, if not, then the appropriate remedy in the face of what you are arguing would be to file a review
my lord, I am before your lordship, my lord, I'll. show that-
without raising the argument before single bench. Why will you be allowed to raise this argument in
That
appeal?
was not in the pleadings, my lord.
Then,
But the rules were not considered, only some citations were considered which were not
Sir,
applicable in view of
if,
the.
and if some argument was not even made before the single
True,
bench,
my lord, that is.
why was it required to be considered?
Then your lordship will give me That liberty, my.
That liberty is there. Can we stop you?
No, my lord, unless there is an observation from your lordship, my lord, that will not be in my favor, my lord, perhaps.
No, you can't prejudge. You say that something was not considered. File a review. Let the single judge decide. And counsel, Senior Counsel, Mr. M.K. Chaudhary submits that as the argument regarding the applicability of rules.
Yes. my lord.
Of which rules?
My lord, there are three rules which are applicable. One is, my lord, Assam Directorate Establishment Ministerial Service Rules. And then, my lord, the Assam.
These are very much referred to in the pleadings of the petitioner. Para 7. Take your own time and think over it, sir.
My lord.
The rules are referred to in the pleadings.
In the
Read page para 7.
Yes, my lord, not that elaborately. That's why. My lord, let it come after a few days. Let it come on Friday, my lord.
1 week. Yes, right.
Item number 16.
May it please your lordship.
Yes.
May it please your lordship. I'm
Yes.
extremely sorry, my lord. Today in the morning, we have filed an IA. Is not tagged along with the record. Let this.
What is the IA about?
My lord, in terms of the order of the court, my lord, we are to implement the Assam Rajiv Gandhi University of Cooperative Management as a party respondent. So we have filed that IA for implement, but for some time this file was in the cold storage. But we have filed it, my lord. Your lordship will kindly take it up.
File was in the cold storage. 15/3/23 we gave
That
you time.
I'm sorry, my lord. The order is of 21/12/2021.
Oh.
During those.
And you couldn't file the application.
Yes, my lord.
Mr.
But now
Kawar
we have
submit-
filed it, my lord. They
Senior
are all
Counsel,
the employees
Mr.
who
Kawar
have
submit that he has already moved the application seeking implement. Post up. The rest is direct to tag the same with the file and list the matter after 1 week.
Item number 17.
My lord, in this case, we have entered appearance today. I'll seek for another 10 days time to file the response. I have entered newly as a counsel in this case.
For the appellant.
Yes, my lord. For the petitioner.
For the petitioner, Mr. Kawar submits that he has been instructed to appear on behalf of the petitioner recently herein before and needs some time to complete his instructions. To file what?
To affidavit in reply.
To file an affidavit in reply. List after 4 weeks.
Deeply obliged.
Item number 21.
There is an
Lordship, in this matter, I pray for 4 weeks further time, Lordship, because the matter pertains to 2008, Lordship. So the authority has requested me to obtain instant because they will be providing with the instruction, Lordship. So little time is required.
MS M. Bhattacharya prays for it is granted further opportunity. You want to file an affidavit?
Lordship.
Further opportunity of 2 weeks to file the affidavit. Or like that. On behalf of the respondents. 2 weeks.
Item 22.
Oblige, your Lordship.
Lordship, please. In that Mr. Das is not available today. He's in Mizoram. I am only seeking on instructions that in terms of your lordship's last order, we have already started the exercise. And the list has been prepared by the board. We have also come to a conclusion. There's been a resolution also been passed. We have already passed an order and forwarded the same to the government. We are only seeking 2 weeks time. Your lordships will file and put everything on an affidavit. Everything is available. I just need 2 weeks time to file this on affidavit.
Counsel, what's your good name, sir?
R.B. Fukan.
R.B. Fukan. Appearing for the appellant. Praise for it is granted. For the opportunity of 2 weeks to bring on record the result of exercise taken, conclusions pursuant to exercise taken in compliance of the direction given by this court on 21st March 2023.
Grateful.
List after 2 weeks. As per it.
My presence may be recorded.
Presence.
1 to 40.
For 15 and 17, I will pay.
Public.
Obliged.
Item number 23 to 59.
I'm sorry, Your Lordship, I'm extremely sorry, there's an interim order should continue, Your Lordship. Is it okay?
Interim order shall continue
Grateful.
till next day. Not seen the files. Deal come. Decide everything or क्या? Let's decide. Encroachers. So there is, on the one hand, the encroachers have come
Phone number.
to protect their position or what?
So I am in 24, my lord. 24 is, my lord, that is a land allotted to the various government department that is enclosed by some employee of the, my lord, that department. And that's why, my lord, they have, what the action they have taken, my lord, they had to place before the honorable as per the last
Yes,
order.
the other day we had asked MS Bora to, of Mr. Boru Pusari, where is he?
Now, here in this
Yes.
case, probably. That is in 24, my lord, so motor, that is, my lord, Mrs. Botai, yes, no? Borderline.
Yes, please.
On last occasion, when the writ petitions were listed before this honorable single bench, Your Lordship, the honorable single bench ordered that the writ petitions would be listed. before
Listed with the division bench. All right, understood. But
And thereafter-
division bench, date 6/4, we asked you to provide the status report
Yes, Your
of the circle officers
Yes,
regarding steps taken to remove the encroachers.
yes, Your
Why?
Lordship, I have.
What have you done in the meantime? It's more than 1.5 months.
Lordship, regarding regarding the PIL and writ petition 370
Yes.
of 2022 and writ appeal 370 of 2022, as well as writ petition 7510 of 2022, 8308 of 2022, 7970 of 2022, and 7976 of 2022. Regarding this, they have sought for some more time, Your Lordship, so that the updated status report can be
Where is
placed.
the PIL file? Okay, let us have the PIL file. No, this is a writ appeal. नहीं, इन्होंने दे दिया, पता नहीं. Let's see. We have given you 4 weeks time on 6 April, madam. Then
My lord, in this entire series, my lord, may I brief the actual, in this entire series, my lord, item number 23, 26, my lord, 27. My lord, these are matters, my lord, pertaining to, my lord, writ appeals arising out of judgment passed by the learned single judge of this honorable court.
yes.
My lord, these matters, my lord, the issue here is, my lord, they were encroaching, my lord, government land, my lord, towards the, my lord, highway, my lord, in the city of Guwahati. Now, their writ petitions were, my lord, dismissed. Giving them a leeway, my lord, that within 3 weeks, they will have to vacate. So against that order, my lord,
They have come in appeal.
Yes, and now, my lord, this.
Is there a stay operating in their favor?
My lord, no.
No.
There appears to be no stay.
Then why eviction has not been done?
Yes, my lord, that.
They are, what Mr. Mahanta says, that they are working in the same departments.
My lord.
Is it correct? Some of them.
Yes, some of them ex-employee.
Ex-employees.
My lord, we are awaiting the factual, my lord, ground reports from the officers.
So
Then
we
we will-
directly do, that's what we are saying.
Yes, yes.
6
I-
April.
yes.
We are giving you 2 weeks time. Keep the officers present with the reports.
My lord, and item number 24 is the, my lord, PIL suo motu initiated by this honorable.
Yes.
Arising out of encroachment of government land, my lord, in the district of Kamrup Metro. And from item, my lord, 28 onwards till 59.
Single bench judgment is writ petitions wherein the encroachers have come and procured stay.
Procured stay, and that, my lord, land in question is reserved, my lord, for construction of. the-
Institutional land.
The second medical college in Guwahati. It is for the second medical college in Guwahati, and that has already been earmarked in the record of rights as my lord, land allotted to TB hospital. Now,
Okay.
land allotted to TB hospital will now be, my lord, rescheduled and, my lord, diverted for, my lord, allotted for the purpose of construction
Alright.
of second medical college. This is how, my lord.
All right, who are the councils who are representing petitioners in 27 to 59, please? No one? Yes,
I am in 25.
yes, please.
25, my lord, there is 11 petitioners. My lord, previously they approached before the Honorable High Court. And single bench, my lord, lordship will find. As directed the Deputy Commissioner, those who have filed application for settlement. Some persons are residing for last 25-30 years. And they are outside the boundary of the TB hospital. There is some wasteland, government land, my lord. And their applications are lordship will find page, my petition, page 21 onwards, my lord, series. And accordingly, that was considered and proposal has been sent to the government for providing settlement, my lord.
Okay.
They are in this position, my lord. So they are under.
What about
consideration.
those who are falling within the precincts of the land reserved for the hospital? How many of those persons are there?
We say, my lord, we say that
All.
all.
What
They-
Learned
they-
Council says that the proposal for settlement has been sent to the government.
Yes.
Dismiss it.
Yes, my lord, we have kept it
Take a
in-
decision, whatever you want to do.
We have already kept it in-
All right.
And
And council, Mr. Pusari and MS and Bodloi, pray for short opportunity to complete their instructions and place the status report on record. On the next date, the concerned deputy commissioner shall remain present in court with the complete status report.
My lord.
Yes. On. This will come in the suo motu PIL
Yes.
list on 20th June. And the other matters list along with so and so on 20th.
My lord, yes, my lord.
Okay.
And so.
Item number 60.
They're not very- Commercial. Yes. कोलैप्स हो गया ना इसलिए पता नहीं चला पासवर्ड स्पॉट नंबर 6 सर्विस देखना होगा सर्विस का क्या होगा is entered appearance password password is always something. I mean, if it goes to the next date, it is an adjournment.
May I please the lordship? In this case, this order dated, so page number 321, which has been put to challenge. No. 21/7/2022 lordship, there has been put to challenge. And on the last occasion, while meeting, this stay order is there.
Yes.
And my learned senior friend is appearing in this case.
The lordship may fix a date for
Final hearing.
final disposal.
So we'll confirm the stay order, then admit the petition. What else?
Yes.
Well, it can remain at this, Lord. A
At this
long,
phase.
long drawn battle between the parties.
Okay.
It's a practically second round of litigation they are coming on appeal. First,
Argued today.
Allah, I have just.
We are having a lot of time.
I have just entered appearance today, my lord.
Oh,
Give me a time, my lord, tomorrow or
Lordship.
day after I can.
Lordship may fix any date in the next week.
all right. And see in council, Mr. So has put in appearance. On behalf of the respondent,
Yeah, oh,
please
just
for
one restaurant.
short, respondent number one.
Yes.
Only one respondent.
Yes, only one.
The sole respondent, he prays for and is granted short opportunity to complete his instructions and argue the matter. The interim order dated so and so shall remain in currency list for final disposal on 18th July.
18th.
All
Allah
right.
is Lordship.
Take them out. Take them out. Yes, of course.
Supplementary list, item number 65.
Yes.
Lordship, I have some submissions to make before my friend starts.
Uh,
The updated status of what we have, then we can go into their submissions.
Mm.
As of yesterday evening, Lordship, we still have 19 students who are yet to secure admissions.
Mm.
We are not including the KV schools now because we want to do some more research on that. And the
Kendriya
other-
Vidyalayas.
Kendriya
KV
Vidyalayas, yes,
Kendriya.
Lordship. And
Alright.
respondents 11, 12 and 15. Now we would like to urge upon these three respondents today, Lordship.
Okay.
Lordship, respondent schools 11, 12, 21.
Mm.
Petition copy. Total of 4 students are there, Lordship.
4.
Yes,
Mm.
who may charge fees and they have not refunded the fees till now. 11, 12 and 21, Lordship.
21.
Yes.
Lordship, respondent school 11. Two
Yes.
parents who were very enthusiastic till the last day, till evening of 24th, they kept on calling. But yesterday when we called them, they had a specific request, please get our names out of the list. We feel that they have been threatened and they do not want to, they have not got their money back. They want to continue with 50% of the school fees.
Mm.
Whereas Lordship, parents of 2 students of respondent 11,
Mm.
serial numbers 27 and 28. School has not contacted them and they're still waiting admission in the school of respondent 11.
Mm.
Then respondent 12, Lordship, nobody has appeared as per the cause list till for the school. And we have given the admission receipts and they have not denied, they have not refunded the money till now.
Okay.
Respondent 17, Lordship, they have filed the affidavit. They have given admission to 4 children.
Mm.
And one they said has not been admitted because the application was not there. The parents had taken the forms again and again, but it was not entertained, Lordship.
Mm.
So respondent 17 has again said that they gave the admissions much before, but the dates are all in the month of May, Lordship.
Mm.
They made the parents correct the admission, the application.
Any of
forms
the
and
admissions
change
have been
dates.
given?
One child has not got their Lordship,
Okay.
even now.
Mm.
Then respondent school 21.
Mm.
They have not refunded the fees of the student. That is the update.
Mr. Mazumdar, you are taking note of these submissions.
We have our own instructions. I'll place them.
Lordship, and some schools have completely complied. I would like to come to that also. Respondent school 15, Lordship. 16,
15, 16, just
18, 19, 20, 22, 23. They have completely complied with the list which we had submitted.
15,
before this
16,
meeting.
19.
Yes, Lordship. 15, 16, 18, 19, 20, 22 and 23.
Eighteen also.
Yes, Lordship.
Okay. So now your issue remains with 11, 12
11, 12, 21.
11,
And 17, lot 17 has not refunded, 17, they have not given admission to one child. And 21, they have not refunded the fees.
$21 fee not refunded.
Not refunded, Lordship. And 20, respondent 12, nobody has appeared till date before this.
And what is the status? Have they given admissions? Respond number 12.
They have not contacted the parents, nor given admissions. Respondent 12, Lordship.
11, 12, you say that they have not given admission or they have not refunded?
No, 12 has not given admission till date.
And 11?
11, they have where before this court where we had annexed the money receipts.
They have withdrawn. They have given you instructions to withdraw.
Not withdraw, they just say that they would continue paying the fees, though the applications are under 12(1)(c), Lordship.
Maybe. Okay.
And then 2 children are still awaiting admission in
All right.
respondent 11 school.
Yes. Yes, please.
Maybe. We had issued show cause notices to each of those schools. Madam, first, if I may place, per the Right to Education Act 2009, schools are required to give free admission in class 1 and preschool. In the Kendriya Vidyalayas, madam, when we gave the show cause notice, and they have also filed their affidavit, we went through it. Most of the students were seeking admission from
In higher
class
classes.
to class 8, so they were not. One student, the specific stand of the Kendriya Vidyalaya is that he did not even apply under the.
Kendriya Vidyalaya, she is not arguing for the time being.
I'll just place.
Forget Kendriya Vidyalaya.
How they have gone. One student applied and is in the waiting list due to the lottery system because there were a huge number of applications. Just my lord.
In which school?
The Kendriya Vidyalaya school. The others
Kendriya
were-
Vidyalaya, she is not breaking up that issue for the present.
I'm coming to this. Now, my lord, if lordship should have the third page.
Of
I'm
your
sorry, my lord, the
actual report.
fifth page, my lord. Fifth page, last line, if lordship has, in response to the show cause notice issued by the director, lordship fine, down below the last line, in the second last page.
Page you're referring to?
My lord, the page 4. The
Now that
last
is 4, page 4, yes.
Last line, in response to the show cause notice issued by the Director Secondary Education. The principal South Point School stated that they had received a communication from an NGO on 27/2/2023 via email for admission as free scholars in the school for 4 number of children. As the school was an external venue for the board examination 2023, the new admission session was scheduled to begin from April 2023, and the guardians of the prospective students were informed to meet the school authorities at the time of admissions with original documents supporting their applications as per the
These
requirement.
are lame excuses, Mr.
No,
Muslim.
it's not Lordship will go a little further. The principal also stated in the reply that the NGO filed a PIL claiming non-compliance even before the date of submission of the documents. None of the guardians met the authority for purpose of admission as free scholar under the provisions of RT 2009. Only one guardian of the 6 listed later approached the school authority, and on his request, he secured admission of the girl child in class pre-1, and she was given 50% free exemption against the single girl child. It is further stated in the reply to the show cause that the school authority has likewise admitted students with full and partial fee waiver for which no reimbursement will be claimed from the government, as such waiver are over and above the purview of RT 2009. From the above reply, it appears that the parents had not applied at the time of admission under the RT 2009. However, school has not explained the cost of books, the track pants, and the medical fees. A separate notice will now be issued for them to explain the same. Now, my lord, in case it is a stand of the petitioners that an application under RT 2009 was made. In case the application is there with the school and they did not do it, it's a different issue. In case there was no application under 2009 RT Act, my lord, at this stage, perhaps it will not be open for us to.
All right, what we advise you is that looking to this discrepancy, they say we have filed, you say they have not filed. Let there be a portal of the department
There is a portal, my lord, it was not filed there.
wherein it was not filed.
It was, there is no application on the portal of the website. We specifically asked the school to display the portal. There's nothing on record. That application was formed in the portal. Application in, as per the PIL, the application was made in February. The school had told them to come back in April.
Why?
Before the last date of
Why?
April.
Well, when are the admissions
My
made?
admissions happened in second week of April. PIL came up before that. In the portal, there was no application on the RTE. The person concerned, the one child who has taken admission, had directly approached the principal with a normal application. Where the principal, considering the guide status, gave a noting 50% reduction in all fees. Number the school books is, I've seen the receipt of the school books, where on the bottom of it is written, all returns to be made within 7 days. So it was an optional, what we believe. The track pant only has been brought from the school. No other school uniform has been bought. So that was a voluntary, perhaps, because only a track pant has been bought. Otherwise, the whole school uniform would be bought.
These articles purchased from the school is never voluntary.
My lord,
School, virtually every school squeezes the parents to do that. Don't even think of that.
that is what
That
the
is never
school
voluntary.
expects.
Anyhow,
Other-
one track.
Otherwise,
the big deal.
Otherwise, the medical examination scheme, from what I know, is a voluntary application. It's a voluntary fee given by the parent for a monthly medical checkup in the school. If not given, the child is not subjected to the examination or a regular examination. It is the option of the parent. That is what has been given to us. In case the school cannot show those things, or in case they have some instruction to the contrary.
Madam, what you are saying, bring it on record by way of an testimony. Don't go on oral submissions. Bring all these facts on record to an affidavit. They will have to respond.
By the PIL which we had initiated before this one on 10/3/2023, which is part of my PIL lordship at page 52. The honorable court had directed the education department to come up with the notifications and before 1st of April, and our applications reached all the schools before 1st of April, physical applications lordship. Online applications were not there because the schools have not displayed their website with RT applications, open for RT applications.
Okay.
So lordship, my friend saying that the applications were received after that, it is completely wrong. Because our records, I can place it before this court, we filed applications for all 48 children before the 1st of April as per directions of this court lordship.
So all right, place them on record.
Yes,
Then we'll ask them to respond.
No, lordship, I will place them, but this would be an academic discussion. What my friend is suggesting, books, this, that, let him come to the main root of the cause lordship, that they are not open to our 12-1 RT, 12-1 admissions lordship. One single child, what he's referring to, he's making a big thing of it, that single child, single girl child admission. That means only one child can apply or what lordship? What does the single girl child mean? Is he emphasizing that girls come, but we give only admission to one girl child?
No. Fee, the part fee has been waived because she's a single girl child of the parents.
That is what
No, lordship,
the
that
school
is-
has told us they have done.
Lordship, that is there.
I'm not
on
the
that,
counsel for
but
the
there are the other admissions which they have refused, and this is not the only time. 20 lordship will listen to me. Lordship, I'm sorry, lordship will give me some time. 20, we filed the first petition. 21, they come up with an OM. 22, nothing happens. We again filed RTIs. And 23, when they have not admitted, the schools are not responding. In the month of March, lordship, we have very little time because of the RTIs replies we got. So we get an order, the
You
government.
satisfy the court that the applications, madam, just hold on. Now you listen to us.
Yes,
To
lordship.
satisfy the court that the applications were filed in time and the children are entitled to be admitted under the RTA Act, and we'll give you necessary.
Lordship, that we have already.
Please show us the application.
Lordship, in my affidavit first, the affidavit we filed.
Let us see.
Lordship, this is just one of those applications. Lordship will come to 116.
So now they are disputing every one of your claims.
This is an
How
application
to
of March. We started
Yes.
admissions in April.
No, lordship.
It
She
is not
says,
in the
Mr.
website.
Mazumdar,
It is not in
she
the
says that under the direction of this court, they have to file the applications before April.
Yes, lordship. Let him come to the activity calendar of the OM lordship. This is page 43. Page 43 says the activity.
Don't follow the
calendar of
instructions
OM
blindly.
lordship.
Apply your mind. Yes,
Lordship, page 43 of my PI lordship, it
Yes.
says unaided non-minority private schools shall prepare the details of entry-level class and intake capacity by 15th March of every year.
That is a preparation. When are the applications to be received?
Applications, Lordship, will come a little below, Lordship.
Yes,
Issue of
4.
application forms.
4. It's
For
issue
admission,
up
yes,
to 25th March.
25th March.
And filing
Lordship,
submission is 28th March.
20th March.
Yes,
Everything
Mr.
is- it is
Mazumdar.
there
This
under, Lordship.
25th of March, the application opening on the portal was there.
They
The
don't have a
28th
portal.
of
Today he is telling
the
he has a
28th of
portal.
the 28th of March.
Show us the portal, exhibit it right now.
My lord, one go ahead.
Open, anyone give him a pad,
Lordship,
a phone.
as per
Open
our
it on your
research-
phone and let us know.
As per our research, only one school in Guwahati, Sanskriti, the Gurukul, has a portal because we kept on checking all schools randomly most of the times.
Open all, school council are here. Open the portals. Let us see. Come at 2 with the picture shot of the screenshot of the portals. Active portals. Come back at 2. And you give whatever you have stated, give it a brief note, hand it over to Mr. Mazumdar.
Much.
For the number 11, they have filed the affidavit. And we allowed to call for the affidavit.
A copy has not been served to me, Lordship.
So serving or not.
My lord, do I retain the secretary or?
He'll join through VC. Let him join through VC. ये देना उनको वापस. वो put it there.
Item number 66.
May I please your lordship, on last occasion, Learned Standing Council Agriculture placed an instruction on record, lordship.
MSCPS, second.
Yes, lordship.
So
He submitted that I'm eligible for second one, lordship.
they're sanctioned.
Lordship.
Then what do you need now?
No, lordship.
In view of the land council, MS Kanugu submits that as the benefit of second MSCPS have been sanctioned to the appellant, she is no longer, she has been instructed not to continue with this rate appeal. Hence, what else?
They will provide me the benefit, lordship, within the time.
Already sanctioned.
Sanction.
Order you have not got. You have not got the copy or what?
This copy, they didn't,
Sanction order.
lordship,
Then what do you want? 16.5.
lordship, within
New pay band with effect from 1/1/19.
lordship.
Come on.
Yes, sir.
The cause of action does not survive to the appellant, hence the writ appeal is closed.
Lordship, in the meantime, there is a stay in recovery part. There was an order of recovery.
The recovery is effected from the petitioner. Where is the recovery?
Recovery, lordship. Last page of my writ appeal, lordship, 68, page number.
The recovery sought to be made from the appellant. They will be adjusted against the benefits of MSCPS. What else?
Lordship.
Shall the decision to effect the recovery from the petitioner. Page number?
68, lordship. Last page of my writ appeal.
By virtue of the order dated 21/1/2023 shall steps to effect recovery from the petitioner by virtue of order dated 21/1/2023 shall be reconsidered in light of the fact that second MFCPS has been granted to the appellant from 1/1/2019 with effect from 1/1/2019. It will be set off most likely.
Lordship.
With the above observation, the writ appeal is closed.
Lordship.
Item number 67.
Please, your lord. 27 for your lordship had passed the status quo order. Person there to.
Please, lordship. Lordship, we have filed affidavit in opposition on Friday, but it has not come on records. I've already received a copy.
And Councillor Ms. So appearing on behalf of Mr. R.K.D. Chaudhary, Deputy FG, praised for and is granted. I submit that she has already filed the affidavit in opposition. The same be brought on record. List on
A week later.
After 1 week,
Lordship.
after a week.
It can be after tomorrow also, Lordship.
List Friday credit charge, list on Friday.
Of license.
There is one passed over matter. Passed over.
Well. Item number 14, passed over matter.
We have to wait for your appearance to admit the appeal. Your associate says, sir, if you admit it without Mr. Chaudhary's being here, he will not be able to raise the fee, bill of fees. Admit, issue notice. The respondents, all respondents are represented.
Well, I am representing the finance department, my lord.
Mr. Bozari appears for the respondent number so and so.
3 and 4, my lord.
3 and 4.
My lord.
Who are for the 1 and 2?
My lord, the education department authorities, my lord.
Ms. Bora appears for respondents numbers 1 and 2. Thus, service is complete and notices need not be issued. Connect and list with so and so. Deep down.
But the connected vehicle is my lord, WA 156 of 2023.
Give us slip, give us slip.
My lord. And so obliged.
Okay.
Item number 12, passed over matter. Deep down.
We have Mr. Lordship. Lordships, item number 12 and 60, kindly, take up these matters at on witness the Lordship. We have some personal difficulty with the Lordship.
3 and
12 and 60, Lordship.
12 and 60.
Yes, Lordship. Pass over matter.
1 week.
My lord, this matter, we had to file a reply,
Do it. How much time do you need?
but we have the documents. My lord, there's nothing to be filed, my lord. We have the records with us. They
All
speak
right.
for themselves.
Argue after 1 week.
Deeply, Lord.
Right, please, Lordship. In this case, petitioner person is not well, Lordship. Pass over for the week, Lordship.
Why?
She's not well, Lordship. Petitioner in person, she's not well, Lordship. She's like-
Petitioner in person.
Yes, Lordship.
Swati, all right. Okay. The petitioner. She normally, the petitioner appears through VC,
She's appearing herself, Lordship. She's appearing herself, Lordship, in this case.
but normally the petitioner addresses through VC.
No, today she informed me about phone that.
The petitioner is not available to argue the matter today. List up 4 weeks then.
Blue, please.
There's one more 68. 64.
Lord, before my friend starts, my lord, there has been a new development in the case.
What happened?
And development is that, my lord, the there was a CBI case based on which, my lord, the disciplinary proceeding was sought to be initiated against me. And 15th of this month, my lord, that I have been acquitted out of that CBI case by the Honorable Bombay High Court. I just want your lordship's permission
This
to
is a
bring
case
that.
of concluded proceedings or proposed proceedings?
No, purported proceeding. I just want to bring that order of the Honorable Court to your lordship's notice, my lord. Short
Would it be relevant, sir?
My lord,
Because disciplinary proceedings and criminal case, they can proceed parallelly. There's
Now-
no difficulty about that.
my lord, the CAT, or the Honorable Central Administrative Tribunal has quashed the proceeding on mainly on 2 counts. First of all, there has been a delay of about 10 years in initiating the proceeding against me. And
Yes.
secondly, my lord, that the charges in the disciplinary proceeding are exactly same as in the criminal proceeding. Now the criminal proceeding has gone because the Honorable Bombay High Court has passed an order, my lord, on 15th of this month, by which, my lord, I have been acquitted of the charges.
That's in council, Mr.
Lord,
Is the appearing for the, yes, madam.
Lordship, that can be taken as a ground, Lordship, in his defense, Lordship, before the authorities, Lordship.
All right, you are in appeal, you are in writ against an order quashing the proceedings.
Yes,
So any matter favorable to the employee, he'll try to bring on record
lordship.
appearing for the respondent submits that the criminal case registered against his client on the basis of very same allegations which are the subject matter of the disciplinary inquiry, has resulted into an acquittal oblique exoneration.
That's a discharge.
Exoneration कर दीजिएगा.
Exonerate.
And that he wants to bring on record the order of the competent court for the court's perusal. Needful be done within 1 week, list thereafter.
Obligement.
Fix the plot.
Sorry. 15th June, no, not 15th. Too many matters on 15th. 20th June.
Lordship, obliged.
In 1 week, 1 week mat karna. Same be brought on record list for hearing on 20th June.
Obligement.
Supplementary list for hearing item 68.
Malab, these matter, Malab, that relates to correction of date of birth by the son of the Malab, the railway employee, Malab. He, the railway employee already died, Malab, in 2001.
Yes.
And Malab, son, Malab, showing that his date of birth should be 1996. But the employee, while in service, he recorded
it in the nominations.
1992, Malab. And this record was in 1994. Lordship, I have last look at the
Any
place.
of, apart from that, we have put a question to current council, how the
Section-
tribunal has jurisdiction to entertain.
Yes, yes, that is the section 15.
Yes,
Perhaps
please.
normal.
No, so far as jurisdiction is concerned, that is
Administrative Criminals Act.
lordship.
Then.
Section 14.
Yes. Read, please.
Now, in this case, the petitioner has come for getting family pension.
Yes. No,
Yes, your
that is not the primary prayer. The primary prayer is change of date of birth.
not change of date of birth, correction of date of birth. your
So
lordship.
yes, that is the
Correction of
primary.
date of birth.
In what record? Not in the record of the employer. In your own records.
Not in my own records, in the
Then-
record of the employer. In the record of the employer, because
All right, tell us any procedure by which the CAT can do that. Change in date of birth of a family member of the employee.
I have not come for change of date of birth for anything else, but for the family pension, which I have. been denied.
Irrespective, sir, irrespective. That is a consequential act. The first and foremost relief you seek is change in your date of birth. You are not the employee. You have no connection whatsoever with the employer. No direct connection.
No direct connection.
So then why the employer is supposed to make any endeavor to change your date of birth in the records? Unless it is on the basis of the order of a competent court.
No,
And
so,
competent court for this purpose can never be the tribunal.
lordship, so far as the date of birth is concerned, they are not saying that my date of birth is not.
We are
correct.
not, yes, they are saying.
No, your lordship.
Oh, that's really amazing. They
Lordship.
say that the employee while he was alive, he himself gave a nomination detail wherein the date of birth is given. Your claim is you are born thereafter.
Their claim all throughout is that, your
Sir,
lordship.
read just 2 lines. Read that document, Mr. Counsel.
Page 17, my lord.
This is just a joke.
This is the family declaration.
What date of birth you are claiming?
15/4/1996.
15/4. When was this family detail document given?
There are
Document dated 26 to 1994, my lord.
94. So presumably you were not born then,
not.
as per you.
Lordship.
Now read, what is the name?
Barik Mian Sodhuri.
Read number 5.
Lordship.
You were not even in existence.
Lordship.
How your father could give that detail?
Lordship will kindly see in the right side at the bottom, he put his thumb impression, lordship. He was a grade 4 employee. He was a.
Sir, they knew that
Illiterate person.
Oh, wonderful. They knew that one Banik Chaudhary will be born to the employee later, so we put in his name.
No, but there is also a counter signature on 14/3/2002, your lordship. Lordship will kindly say this aspect of the matter has been considered by the learned tribunal below, your lordship.
May I clarify that, my lord, counter signature? While the my lord, employee retired, my lord, in 2000, one, my lord.
Mm.
While processing this, my lord, this counter signature was put.
Yes.
Otherwise, this entry is dated 26 to 1994.
Yes.
My lord, right side, my lord, down below.
We have seen that.
Yes. So for counter
This
signature.
council, you will lose the chance even to go to the civil court. We are making it clear. We are absolutely firm. Tribunal has no jurisdiction, no business to entertain that. No business at all. Let's see your prayer in the tribunal.
Lordship will kindly see it. My OA is at page number 34. It starts at page 34, your lordship.
Relief.
Relief. My relief is at page number 38, your lordship.
Yes.
8.1.
9.1.
8.1.
Yes, 8.1.
May I read, your lordship?
Yes.
To direct the respondent authorities to make necessary correction of the date of birth of the applicant as 15/4/1996 instead of 15/4/1992
Yes.
in the official records and grant family pension to him till he attains the age of 25 years.
Yes.
They in fact had granted family pension which he was receiving, but because of wrong date of birth, your lordship, it was stopped in between. Even when they have submitted the written statement, your lordship,
Yes.
their claim was that, your lordship, the date of birth that the employer has given, they
Mhm.
cannot be changed at this stage.
Yes.
And the date of birth that I am now, because lordship will kindly see the record, there is not a, from page number 41. It is the birth certificate, your lordship.
Give the document whereby he was first admitted in school. Bring that. That is the test. JJ Act section 94.
Lordship.
First admission in school. Give us that admission form. Bring. When?
And 2 weeks time may begin.
Anyhow, we don't need to go into that. You argue on the jurisdiction of the cat to entertain this
Lordship.
Original application. Argue on that.
Lordship. Because had they said that my date of birth is not correct, lordship will kindly
The
see.
cat has gone on to make an inquiry into the date of birth of the son of the employee. Does the cat have jurisdiction with that? We have to set things right. We have to make the procedure correct so that the cat doesn't make this blunder in future. We'll do that. If you have anything to say on that aspect, please make your submissions.
So far as jurisdiction is concerned, that is being provided in section 14.
Yes, read.
Jurisdiction, powers and authority of tribunals.
Yes.
Save as otherwise expressly provided in this act.
Yes.
The Central Administrative Tribunal shall exercise on and from the appointed day all the jurisdiction, powers and authority exercisable immediately before that day by all courts except the Supreme Court in relation to recruitment and matters concerning recruitment to any All India service or to any civil service of the Union or a civil post under the Union or to a post connected to the defense or in the defense services, being in either case a post filled by a civilian. All service matters concerning a member of any All India service or a person not being a member of an All India service or a person referred to in clause C, appointed to any civil service of the Union or any civil post under the Union. A civilian not being a member of an All India service or a person referred to in clause C, appointed to any defense service or a post connected to the defense, and pertaining to the service of such member, person or civilian in connection with the affairs of the Union or of any state or of any local or other authority within the territory of India or under the control of the government of India or of any corporation or society owned by or controlled by the government. All service matters pertaining to service in connection with the affairs of the Union concerning a person appointed to any service or post referred to in subclause 2 or subclause 3 of clause B, being a person whose service have been placed by a state government or any local or other authority or any corporation or society or other body at the disposal of the central government for such appointment.
Yes.
So, your lordship, all service matter pertaining to service of a.
How is it a service matter, sir? That's tell us. How is your relief a service matter?
Service matter that has been again defined in section 3.
3Q. Read, please.
Service matter in relation to a person. Means all matters relating to the conditions of his
His
service.
service.
His service.
So this is not a condition of his service.
The pension is a condition of the service of the petitioner's
Yes,
father.
yes. So his father could have raised any kind of dispute. The petitioner, Mr. Counsel, tell us what inquiry has the cat indulged into to find out the correct date of birth of the accused, your client.
Not to find out, your lordship. There is only a correction that is required to be made, your lordship.
So
They
for
have not-
that, what have they relied upon? Evidence given by you?
Lordship,
What is the process for determination of date of birth?
I have given all my certificates, and they have not said that my certificates are false or it is not.
They are
there.
not required to. They are not. They say that while the man was alive, he gave the name of his son and gave out his date of birth as 15/4/1992. That was in 1994. So there is no reason for them to believe that the son who was not even born, his name will be mentioned in this record.
Lordship, then we'll go through the judgment of the learned cat below, or lordship will kindly come to page number 11, 16.
No, read the judgment.
Grounds that they have taken.
Read the judgment, please.
Lordship, initially the judgment was a divergent view. Judicial member supported that the date of birth requires to be corrected, while the administrative member said that no, the date of birth that was given by the employer that should remain intact. The
Yes.
matter was referred to a third member, and the third member also opined in favor of the judicial member. So the judgment was passed by a majority of 2:1, your lordship.
Yes, read.
Lordship will kindly see. I'll take a lordship to the judicial member judgment, which starts from page number 66.
Yes.
And I'll take your lordship to relevant paragraph. Page 66, lordship has got it. This was by member judicial. And the relevant page is page number 71, your lordship.
71. Yes.
71. This is the view of the learned judicial member.
Yes.
Having heard paragraph number 9, your lordship.
Yes.
Having heard the learned counsel for the parties, perusal of the pleadings and materials placed before us, we need to first ascertain as to whether declaration made by the deceased father in the declaration form stating the date of birth of the applicant as 15/4/1992 will be counted for family pension, or on the basis of certificates of Board of Secondary Education Assam, that is admit card of high school living certificate examination 2012, high school level certificate examination 2012, HSLC pass certificate issued by the Board of Secondary Education Assam dated so and so, registration card of the Board of Secondary Education Assam dated so and so. That apart, applicant has also annexed copy of the passport, PAN card and Aadhaar card. Applicant's father Sifat Ali Chaudhary, who was technician grade T mason, died in harness on 28/9/2001. During service, deceased father did declare his family members in the declaration form dated 26/2/1994, which is annexed.
Come to para 13.
Lordship.
Read para 13.
1-3.
Yes.
At page 74, your lordship.
Proof of evidence of date of birth. So the tribunal indulges into appreciation of evidence to determine the age of birth, date of birth, which is not permissible. Sir. Simple as that. They need not have disputed. There was no scope for such an inquiry in the cat. Date of birth, that too not of the employee. Even if the employee wants to get it changed, he has to file a suit for declaration. You realize, even the employee cannot come to the cat and say that please change my date of birth. That is a declaration suit which is required to be filed.
But we have found your lordship judgments where on the basis of because of wrong insertion of date of because the date of birth which his father entered, it was not on basis of any records. It is not that in that record some other document was there and subsequently he has given some other document and
So you want a declaration that what was entered by your father was wrong? That declaration is pertaining to your date of birth.
Lordship will kindly see page number 11, one of the grounds that they have taken.
They have, all right, come on Thursday, bring the admission form into the first school first admitted.
My lord, moreover, one submission, my lord. The subsequent, if irrefutable documents are also placed subsequently, my lord, that may not have the consequences. Because the relevant time document would be required. And that is the judgment 2003-6 SSC, my lord, 483. State of UP and others versus Gulaisi. My lord, here, para 11 is short judgment, my lord. Lordship may kindly peruse this judgment, my lord.
Read, please.
Yes. Well, even if. No. Well, before that.
Para 18.
But here from this judgment, my lord, paragraph 11, internal page at 2003 6 SCC 483.
Yes.
My lord, internal page 489, para 11, my lord. As observed by this court in state of TN and TV Venugopalan and the state of Orissa Ramanath Patnaik, when the entry was made in service record, when the employee was in service, he did not make any attempt to have the service record corrected. Any amount of evidence produced subsequently is of no consequences, my lord.
Yes, yes.
My lord, for this purpose, my lord, this is the judgment. And this judgment was also relied upon by this honorable court. My lord, in 2006 4 GLT 514, my lord, para 6. My lord, my submission is that, my lord, even you assume, my lord, in 1996, this person, my lord, born, my lord, the father expired in 2001. So he, in 2000, within 2001, he would have, my lord, taken the steps for correction. Now at this village, after availing all these benefits, my lord, to get extra benefit for 2 years, that may not be, my lord.
Yes, all right. We'll dictate the order.
Lordship will kindly, I will produce that record, your lordship.
Not required, not required.
Because subsequent document.
We'll lay down the procedure. Cat has no business.
Yes, lordship will kindly, I will also like to place a judgment, your lordship.
Right, sure, please.
But the Supreme Court allowed correction of date of birth of the employee, your lordship. On the
Let's
basis
see.
of the.
Let's see. Employee. Maybe we could have considered, this is son of the employee. Nothing to do with his service. That's where the difference is.
Paragraph 8, your lordship.
Yes.
On the basis of the above, we find that within the given set of facts, the dispute is regarding the manner in which the date of birth should be determined, whether the reliance should be placed on the set of records being the minor's Sodor certificate and the school living certificate, which state the date of birth to be February 6, 1950, or reliance should be placed on the extracts of Form B register, which state the date of birth to be February 15, 1947. Here, an employee at the time of his joining the service, he gave a date of birth. Subsequently, on the basis of record, he said that the date that I have earlier given, it was wrong, so it should be corrected according to the school living certificate, your lordship. At that time, the authority objected that he has raised this issue at the fag, but the Honorable Supreme Court said that if it is on the basis of record, that is required to be corrected. I'll take paragraph number.
Yes.
11, your lordship. 11, your lordship. As stated earlier, this court needs to decide the manner in which the date of birth has to be determined. It is the case of the appellant that as the respondent raised the dispute at the fag end of his career, and as there exists a set of record being
Come to para 9 and the middle part thereof.
Lordship.
Whenever any such question arises, just above para 10.
In the corpus of service law over a period.
Whenever such question arises, the onus is on the applicant to prove the wrong recording of his date of birth. What proof have you given regarding wrong recording? First, let us see that.
Lordship, wrong.
Wrong recording, what is the proof you have given?
Because I am.
Because your father patented the thumb impression, so it should be presumed that it is the wrong recording.
Not also. And secondly, your lordship, no document was submitted at that time.
Not required. Why the authority should believe that the employee doesn't know the date of birth of his children?
That should not be your lordship. And
then,
and since he is an illiterate, your lordship, the learned court below has considered this fact.
Yes.
Considered this fact, your lordship.
Yes.
This is the case of only a minor pension. I have calculated if he gets the minor pension, he will get only rupees 1,50,000.
Why should? That is taxpayers' money. Why should he get a single penny?
And he was a minor. The issue that he has taken that he has not come earlier. He was a minor all along.
Writ petition is allowed. Order set aside.
Lordship, I'll bring this document on record.
Not required. Not required. If we are on jurisdiction, and you want liberty, we'll give you liberty to file a civil suit if you want.
That will go. And lordship is also a court of equity, your lordship. This person,
there's no equity in your favor of client, sir.
This minor son has
absolutely no equity.
This minor son has approached before your lordship in 2019, your lordship. The learned single judge has come to a conclusion. I'll take your lordship.
Wrong conclusion, sir. Absolutely.
At best, your lordship, he may be allowed to come before this court, your lordship.
File a suit. That's the only remedy.
It will take another 4 or 5
Let-
years and
let
he is
it
a minor, your lord, he was
let
a
it
minor,
take-
your lordship, just he has lost his father at the age of 12 and then his mother at the age of 16, your lordship. Kindly, your lordship, it is a
He
court
is
of
not
equity.
entitled to public largesse at the whims and caprices. The law is well settled.
It is not,
Procedure, what has to be followed, it has to be adhered to the hilt.
correct, your lordship, I agree. But when he approached this honorable single judge, your lordship, the single judge has given a categorical finding. Lordship will kindly appreciate, because otherwise would, at that time, if the learned single judge had said that no, your appropriate remedy lies before the civil court, definitely would have gone to the civil court, your lordship. And
Yes.
that order, they have also not challenged. They have also.
Gentlemen, the single judge can't confer jurisdiction of the tribunal beyond what is provided in the act.
They cannot do it, but,
That's it. Simple answer.
but that a view has been taken that
Yes.
the subject matter of the present dispute lies within the domain of the cat and therefore the liberty is
No,
granted.
It was
to
a
the
wrong
petitioner.
view, sir.
Lordship,
We can't affirm that view.
Lordship is a court of equity, your lordship.
Yes.
This minor son, he has been running from pillar to post since 2018, lordship, and now we are in 2023.
Okay.
Lordship will not relegate him
He
back to the
already
civil
attained
court.
majority, my lord, now, my lord,
No, he
up
might-
to
he might have
25
attained
years.
majority, but as per rule, he is entitled to
No,
get
no.
family pension up to the age of 25 years.
All
See his fate, your lordship. He, at the age of 12, he lost his father. His mother, he has also lost, your lordship.
Yes, please. That's a very hard situation, but we can't help it. Thank you.
Lordship will, in that case, will grant liberty.
Take that liberty, you say it on at a bar that the appropriate remedies to file a suit, we'll give you that liberty. We'll also decide that the tribunal has no jurisdiction, and in that background, we'll give you the liberty. If it is your statement.
Because if the cat has no jurisdiction, certainly my right should be redressed at any forum, your lordship. That liberty, your
Gentlemen,
lordship will
The,
give.
the issue of limitation will come if you don't take this liberty.
So therefore, I pray that liberty may be granted.
All right, very well. You have a copy?
We just got
We don't- we
the
don't
printout just
You
now.
give a copy, we'll
Yes.
take the matter tomorrow, Mr. Mazumdar.
Only
You
one
take
thing.
your instructions.
I'll just give one, the page 43 or page 41, which was read out, my lord, that office memorandum. I've gone through it. I've gone through that, all the pages, my lord.
Okay.
There is no requirement of a portal as such. The specific requirement is the person is to approach the school and take the form.
All right.
The portal, my lord, here, if I may read, my lord, the portal part is not there at all.
You
So I
only said
thought
that
that-
you only made a
No, no,
statement.
I said, because the allegation was that it was not being allowed, it means you have been sent. So
They have
portals
given
did not
out
get
so much of
anything.
material. Do you want
Oh, yes,
respond?
I'll look at that.
We'll take it tomorrow. All right. And council.
Lordship, the portal which I was referring to is that the education department has, and that is there in the OM.
The
Regarding the
education
schools,
department will have
Lordship,
taken the instruction,
let
it is
me-
in the nascent stage.
Lordship, yes,
We are
allow me to
forming it.
finish. The
not allowed.
notifications which came out pursuant to our PI, Lordship will take this note which I've just handed over to Lordship.
Yes.
Lordship.
Is the secretary
I'm
joined?
I'm extremely sorry, I couldn't do the pagination.
All right,
Lordship.
not an issue, not an issue.
Lordship
Yes.
will. The poems which came out pursuant to my first PI, Lordship,
Mhm.
there it was stated that the schools will have their own websites indicating vacancy position and the parents would be
Yes.
allowed to do online applications. It is there in the notification, Lordship. And
Admission procedure.
yes, Lordship.
Yes.
So, my friend was.
So,
very
Mr.
strongly
Mazumdar,
advocating
Mr.
that
Mazumdar,
South
just
Point-
hold on.
South Point School, they'll defend themselves, please. I'm not with
No,
any school,
I'm
madam.
very
I'm not with
strongly-
any school. Well, that is an allegation which has come up in the media. That has been an allegation when I was sitting outside.
Exactly.
I was told, please prepare a website within the next 2 hours. Well,
Not like that.
it's an allegation against me. Am I supporting a school?
Who says?
Madam said,
No,
let
I
her
asked
say no.
him.
Like that.
Let her say no.
No, he's making a wrong
The
submission.
cuttings- the cut-
Lordship, I asked
I
him.
swear to
where
God, my lord,
is-
that is,
where
that
is
is,
your
that's
By
website?
these things,
Swear to
don't,
God.
don't go by these things.
No, it is not personal. If it is Lordship,
Madam, you address the court,
yes,
please
Lordship.
not the councils.
Lordship, if it is personal,
Yes.
And my learned friend is not required to respond for the respond number 11. Because I
Lordship,
am there and I filed the affidavit. I have narrated every aspect of the matter.
Yes.
Everything is there in the affidavit, Lordship.
You
Lordship,
provide,
I
just,
have got
madam,
a
hold on.
copy of the
You just
affidavit.
properly paginate this note,
Yeah, I will.
provide it to all the respondents. Mr. Mazumdar, you transmit it to your secretary. Come back day after tomorrow.
Lordship, just pardon me for a moment, Lordship.
Just one thing, how the entire aspect of the matter has been presented before this honorable court.
It's wrong, my lord.
Lordship kindly, yes,
It's wrong.
Lordship kindly see the additional.
Let them prove it, it is
You
wrong,
want,
Lordship.
you want to
Lordship,
proceed,
Allow me to
without
submit, Lordship.
you want to proceed without verification
No, Lordship,
or without responding?
no, Lordship, what I'm submitting is from their affidavit, Lordship,
All right,
from their affidavit. They
Yes.
submitted, they filed their additional affidavit. In the affidavit, Lordship, they annexed a document.
let him check.
Is
Now
the-
we'll
Yes,
pass the order already. Yes, point out what you want to point out. Yes, where are you reading? Page?
Lordship, this annexure A, it is in page number 114.
Yes,
This,
you are for the South Point School.
yes, Lordship. My affidavit difficulty is that my affidavit does not come.
Yes, affidavit has come.
Affidavit has come.
This is report number 19.
11, Lordship.
So then why you are insisting?
No, Lordship, this certain allegations have been made against the Southwest School. That's why I'm just responding to that.
Without bringing your affidavit on record?
No, Lordship.
Then
Lordship, day after tomorrow, Lordship, some difficulty tomorrow, Lordship.
the petitioner has presented a short note with regards to the note of submissions in this PIL. Copy of the same has been provided to respective counsel representing the respondents who pray for short opportunity to address the court in reference to the submissions made in this note. The affidavits filed by the respondents in the intervening period shall be brought on record, re-notify on 31st.
My lord, respondent 19 has also filed an affidavit today.
That's already there.
Some person difficulty on 31st.
When do you want? First June.
31st.
Lordship, I'll provide copies only to the respondents which we agree. Those who have complied, we do not give
All
them
right.
copies, Lordship.
All right. Yes, she has already made a statement to that extent.
It is only 11, 12 and 17. We'll provide them the copies,
right.
Lordship.
Since the petitioner has grievance against, the petitioner's grievances survive only against the respondents numbers 11,
12
12 and 17,
and
copies of the
21.
short note be provided to learned counsel representing such respondents and so also to Mr. Mazumdar representing the department.
We'll do that. Even respondent 21 will give a copy.
All right. And madam, no need to make personal aspirations on counsels.
Lordship, I'll just.
Don't exceed your limits, please.
I have not. Lordship, since my friend was coming to that counsel for respondent 11, the other day in the library, he told me if I'm espousing the cause in for these children here, they should be sent to government schools. That is this remark he made to me and I
That's
told
a
him, please
different thing,
submit
Lordship.
it
It is
before
not
the
on
court.
record. It is not on record.
Why you are indulging these bickerings outside the court?
Ask him
Lordship,
if
it's-
he
Why
has
are
not
you,
told me
why
this.
are you required to do that?
No, Lordship, it's not like that. It's a communication that was because my learned friend has told me.
Why
that-
are you required to
Lordship,
make
my learned friend has told me,
such-
yes, Lordship. My learned friend has told me that they were not allowed to enter into the school premises. That was absolutely incorrect statement, Lordship. So if these sort of statements are being made and circulated, then there is requirement of responding. to
Why
that.
do you need to retort?
Yes, Lordship, I
outside
will
the
not
court?
retort to that. I'll stick to my record and I'll place all the facts before the.
All right.